Hello and welcome everyone. This video is not going to be like my other videos on Jeremy. This video I will break down what he was just convicted of and sentenced to involving the IRS, as well as break down and explain the arrest warrant and charges he will be going on trial for in June. I think it will help show what else he has done illegally, as well as show his blatant disregard for anyone other than himself, as well as his willingness to include innocent people in his attempts to defraud companies. United States District Court, Middle District of Florida, Orlando Division, United States of America, versus Jeremy Charles DeWitte. Defendant. Case number 6:24 CR 00074. JSS of EJK. United States Sentencing Memorandum. Defendant Jeremy DeWitte was indicted in March of 2024 on 2 counts of filing false tax returns in violation of 26 U.S.C. Section 7206 for failing to report most of the revenue he earned from his funeral procession escort business. From 2016 to 2018, he omitted from his tax returns more than $475,000 in gross receipts, causing a tax loss over $100,000. DeWitte pled guilty to both counts in the indictment without a plea agreement. With an extensive criminal history, DeWitte's sentencing guidelines range is between 41 and 51 months incarceration. The United States requests the court to impose a 51-month sentence because it is necessary to protect the public from DeWitte's repeated criminal activity and to deter him and others from lying on their tax returns. The United States further urges the court to order DeWitte's sentence to run consecutively to the sentence that the Osceola County Circuit Court recently imposed on him for an unrelated crime. Finally, the United States requests the court to order DeWitte to pay $69,461 in restitution as a condition of his supervised release. DeWitte's tax fraud is only the latest in a long series of state and federal crimes that he has committed over the past 25 years. Crimes that reveal his willful and repetitive contempt for the rules of civilized society. Like filing false tax returns, most of DeWitte's prior convictions have involved deceiving the public or lying to the government. These include 9 convictions for impersonating a police officer, using a fake name to obtain a driver's license, and using a fake driver's license to obtain a U.S. passport. DeWitte's other convictions include a sex offense and 4 other convictions, starting in 2018 and continuing through October of this year, for failing to comply with Florida's sex offender registration laws. The court should take his criminal history fully into account when fashioning a sentence. Facts. DeWitte was indicted on March 27, 2024, for 2 counts of filing false tax returns in violation of 26 U.S.C. Section 7206 for 2017 and 2018. On September 25, 2024, DeWitte appeared before Magistrate Judge Kidd and pleaded guilty to both counts of his indictment without a plea agreement, despite being offered one. On October 15, 2024, the court accepted DeWitte's guilty plea and adjudicated him guilty. The facts underlying DeWitte's tax crimes are straightforward. He lied about his business's revenue on his 2017 and 2018 federal individual income tax returns. And, as the PSR properly counts as relevant conduct, that he also lied on his 2016 tax return as well. But those aren't the only lies DeWitte had told in this case. He also lied to the IRS agents who were investigating him, he lied to the court, and he lied to the probation officer. A recap of DeWitte's lies follows, starting with the tax returns. DeWitte has lied on his tax returns since at least 2016. DeWitte has been the sole owner of Metro State Special Services, a funeral procession escort business. DeWitte was required to report Metro State's revenue and expenses on a Schedule C to his tax return. But for 3 consecutive years, 2016 through 2018, DeWitte filed federal income tax returns, Forms 1040, that understated Metro State's gross income. Table 1 below compares Metro State's actual income with what DeWitte reported. Table 1. Reported versus actual income. 2016 to 2018. Rounded. Year reported income. 2016 $11,000. 2017 $19,000. 2018 $17,000. Total $47,000. Actual income. 2016 $145,000. 2017 $174,000. 2018 $205,000. Total $524,000. Naturally, DeWitte's lies about Metro State's income resulted in his underreporting his tax liability for 2016 to 2018 by over $100,000. Said another way, through his lies, DeWitte lined his pockets with more than $100,000 that belonged to the United States. Below shows the tax loss. Tax loss, 2016 to 2018. Refund or tax. Due per return corrected tax due. 2016 paid $129. Owed $39,280. 2017 paid $1,556. Owed $35,889. 2018 paid $0. Owed $32,016. Additional tax due. $108,870. DeWitte also lied to IRS agents when they questioned him about his tax returns. When asked how he calculated and reported Metro State's income on his tax returns, DeWitte told the case agents that he saved copies of the checks that he received from customers and that he reported all his income. This, we now know from the investigation, which matched client payments and bank account deposits, alongside DeWitte's guilty plea, was false. And DeWitte told other lies to the IRS agents as well. He lied about his clients. DeWitte told the agents that in 2017 Metro State had only 2 clients. In fact, Metro State had 40 clients that year. He lied about his profits. DeWitte told the agents that in 2017 Metro State incurred a net loss. But Metro State was profitable that year. Even allowing for expenses that DeWitte didn't claim, Metro State's 2017 net profit was over $117,000. He lied about his workers. DeWitte told the agents that in 2017 Metro State had only 2 independent contractors. But in fact, DeWitte had over 25 people working for him at Metro State that year. DeWitte also lied to the court about his failure to appear at his rescheduled initial appearance hearing, which had initially been set by a summons. On April 2, 2024, the court issued a notice rescheduling that hearing to 11 a.m. on April 10, 2024. DeWitte failed to appear. He told his attorney that he had car problems, and the attorney relayed that to the court. The court then rescheduled the hearing to the next day, April 11th, at 8:30 a.m. DeWitte failed to appear for that as well. Although he told his counsel that he had been arrested that morning, that was false. The court then issued a bench warrant. Based on his objections to the PSR, DeWitte still maintains that he couldn't attend the April 11th hearing because he was under arrest. Those allegations to the court are dubious, insofar as records from the Osceola County Sheriff's Office report that DeWitte was not under arrest at the time of the hearing, 8:30 a.m. Rather, he was arrested that evening when he turned himself in to the sheriff's office. The sheriff's office reports are attached as Exhibits 1 and 2 to this memorandum. The call report indicates that DeWitte called that office at 6:08 p.m., more than 9 hours after his scheduled initial appearance. Osceola County Sheriff's Office Call Detail Report. The arrest report states that DeWitte was arrested on April 11th at 7:34 p.m. Osceola County Uniform Charging Affidavit. Thus, the sheriff's arrest records show that DeWitte was not under arrest at the time of his rescheduled initial appearance hearing. In his interview with probation, DeWitte reported that he earned a bachelor's degree from the University of Florida. Unsurprisingly, the University of Florida has no record of his attendance. The United States agrees with the final PSR calculations. Total offense level criminal history score. Criminal history category. Guidelines imprisonment range. $108,870. 41 to 51 months. DeWitte objects to the obstruction of justice enhancement. However, without a doubt that enhancement applies to these facts, and the court should overrule the objection. Section 3C.1.1 of the Sentencing Guidelines provides, in pertinent part, if 1. The defendant willfully obstructed or impeded, or attempted to obstruct or impede, the administration of justice with respect to the investigation, prosecution, or sentencing of the instant offense of conviction, and 2. The obstructive conduct related to the defendant's offense of conviction and any relevant conduct, or b. closely related offense, increase the offense level by 2 levels. USSG Section 3C1.1. The application notes to this section explain that a willful failure to appear at a hearing falls within this section. Examples of covered conduct. The following is a non-exhaustive list of examples of the types of conduct to which this adjustment applies. Escaping or attempting to escape from custody, before trial or sentencing, or willfully failing to appear as ordered for a judicial proceeding. As the PSR recognizes, this enhancement applies to DeWitte because he willfully failed to appear at his arraignment hearing. The rationale behind this enhancement is that defendants like DeWitte, who commit crimes and then make unlawful attempts to avoid answering for them, are more threatening to society and less deserving of leniency than defendants who don't defy the criminal justice process. Numerous courts, including the 11th Circuit, have thus held that the enhancement under USSC Section 3C.1.1 is appropriate when a defendant willfully fails to appear for his arraignment. The court should therefore apply it to DeWitte as well. Sentencing recommendation. The United States recommends that the court impose a 51-month prison sentence, followed by a 1-year term of supervised release. This sentence is sufficient, but not greater than necessary to comply with the purposes of sentencing. 18 U.S.C. Section 3553. The government further requests that the court condition DeWitte's supervised release on DeWitte's paying restitution to the United States in the amount of $69,461, which is the tax loss pertaining to the counts of conviction. In determining an appropriate sentence, 18 U.S.C. 3553 instructs courts to consider, among other things, the following factors: the nature of the offense and defendant's personal history, the need for the sentence to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense, the need to afford adequate deterrence to criminal conduct, the need to protect the public from further crimes of the defendant, the need to avoid unwarranted sentencing disparities among defendants with similar records who have been found guilty of similar conduct. For the reasons set out below, consideration of the above Section 3553 factors all counsel in favor of a guideline sentence in this case. DeWitte's tax fraud was greed-driven and repeated. His business took an income of more than $500,000 from 2016 to 2018, yet he reported only $47,000 of that income, less than 10% of the actual amount. DeWitte's fraudulent reporting allowed him to line his pockets with more than $100,000 in untaxed cash. There are no mitigating circumstances underlying his conduct or in his background. DeWitte earned a substantial income, and nevertheless chose repeatedly and consistently to lie on his tax returns. And then he lied to the IRS special agents when they caught him. In other words, DeWitte has no excuse for his conduct. It was pure greed. Given DeWitte's personal history, it is no surprise that he would cheat on his taxes. His lies to the IRS and this court are in keeping with his repeated criminal conduct. He has no excuse for this either. His background is enviable in its lack of remarkability. DeWitte described his childhood as great. He reported that there were no instances of domestic abuse, violence, or substance abuse in his household. Indeed, all of his basic needs were provided for. Yet his criminal history is vast and varied, with 16 felony convictions. Starting in 1998, when he was 18 years old, and continuing through just a few months ago, when he was convicted for failing to comply with Florida law governing convicted sex offenders. Moreover, DeWitte is awaiting trials and sentencing on many more felonies. On January 6, 2025, he is scheduled to plead guilty in an insurance fraud felony case, 9th Judicial Circuit, Orange County, case number 2023-000843, and on January 22nd, he is scheduled to begin trial on 2 more felony sex offender registration cases, 9th Judicial Circuit, Osceola County case numbers 2024 CF 000469 and 2024 CF 000990. There are no mitigating circumstances. Indeed, it is quite the opposite. DeWitte's personal history weighs heavily in favor of a guidelines prison sentence. The sentencing guidelines call for longer sentences for defendants with extensive criminal histories for good reason. Longer sentences protect the public from recidivists. A defendant's record of past criminal conduct is directly relevant to the purposes of sentencing. A defendant with a record of prior criminal behavior is more culpable than a first offender and thus deserving of greater punishment. To protect the public from further crimes of the particular defendant, the likelihood of recidivism and future criminal behavior must be considered. Repeated criminal behavior is an indicator of a limited likelihood of successful rehabilitation. USSG Chapter 4, introduced DeWitte's criminal history, shows him to be a committed recidivist. He has 16 felony convictions since 1998, placing him within the highest criminal history as Category 6. Many of those convictions involve crimes of deceiving the public, 9 convictions for impersonating a law enforcement officer or lying to the government, lying to the state of Florida on a driver's license application, and lying to the United States on a passport application. His lie to this court about his failure to appear for his arraignment is consistent with these prior convictions. He is someone who thinks that he is above the law and can lie his way around it to suit his interests. Apart from the 16 prison sentences he has already received, with sentences of 8 days, 1 sentence, 1 year, 4 different sentences, 18 months, 6 different sentences, and 4 years, 1 sentence. DeWitte has also been jailed on multiple occasions for violating probation or the terms of his supervised release. DeWitte's criminal history score of 29 reveals him as someone for whom prior prison sentences have had no effect on his willingness to commit more crimes. The only way to stop DeWitte from committing crimes is to incarcerate him. The need to protect the public thus calls for a guideline sentence that fully takes DeWitte's criminal history into account. Conclusion: DeWitte's tax fraud cannot be reduced to an oversight, a mistake that spiraled out of control, or a single instance of lying. He lied on 3 consecutive tax returns and lied some more when the IRS caught him. He then lied to this court about his failure to appear at the initial appearance hearing, attempting to delay his reckoning, and lied again to the probation officer. This court should protect the public and deter DeWitte and others by imposing a serious prison sentence here. The United States respectfully requests, therefore, that the court impose a guideline sentence and sentence DeWitte to prison for 51 months, followed by a 1-year period of supervised release, with such release conditioned on DeWitte's paying restitution to the United States in the amount of $69,461, the tax loss pertaining to the counts of conviction. The United States further requests that the court order that DeWitte's prison sentence run consecutive to the state sentence imposed on November 1, 2024, by the Osceola County Circuit Court. Dated December 30, 2024, respectfully submitted. Roger B. Handberg, United States Attorney. That was a brief rundown of Jeremy's IRS/tax fraud case that he recently got sentenced on. Many people have made comments about how the business made good money, and they were right. Sad that it wasn't good enough for Jeremy. His obsession to be in some form of power and to feel important only managed to make him pathetic. Over 75 different cases in Orange County alone, mostly repeating the same crime over and over and over again. He is going on trial in a few weeks for these 9 felony charges, and if convicted, any sentence would be added to the one you just heard he is already serving. The court will also take into account the habitual offender aspect, which could double his time he will be ordered to serve. Thankfully, the judicial system has finally had enough of dimwit DeWitte, and I honestly will be surprised if he makes it out of prison, period. Here is a breakdown of what he is still facing. Case type: criminal felony. Date filed: January 19, 2023. Location: Division 20. UCN 4820-23CF000-843000 AOX. Judge: Michael S. Kranick. Status: open. State of Florida plaintiff: Jeremy Charles DeWitte, also known as J. DeWitte. Jeremy D. White. DOB February 10, 1980 defendant. Office of Public Defender. October 11, 2020. 1. Organizing, planning, or participating in an intentional motor vehicle collision statute, 817.234-9. Second degree, felony March 2, 2023 denied January 19, 2023. 2. False and fraudulent motor vehicle insurance application. Statute 817.236. Third degree felony. 3. False and fraudulent motor vehicle insurance application. Statute 817.236. Third degree felony. 4. False and fraudulent insurance claims. Statute 817.23411. Third degree felony. 5. Failure by sexual offender to comply with registration requirements. Fail to provide motor vehicle info. Statute 943.04352B3. Third degree felony. 6. Staging motor vehicle crash. Statute 817.2349. Second degree felony. 7. False and fraudulent insurance claims under $20,000. Statute 817.23411. Third degree felony. 8. Obtain property by communicating fraud property over 300. Statute 817.0344 B1. Third degree felony. 9. Organized scheme to defraud under $20,000. Statute 817.0344. Third-degree felony. This case started out in March 2020 and was brought before the court once again on January 17, 2023, when an affidavit requesting an arrest warrant was filed, and the request was granted on January 19, 2023. This actually happened while Jeremy was already in custody at the Orange County Jail while being held for failing to comply with the conditions of his probation for unrelated felony charges. Later that day, Jeremy was booked and processed for the 9 new felony charges. This is the affidavit for arrest report and breakdown of the new charges. In the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida affidavit for arrest warrant court case # 2023 CF 843A0. State of Florida versus Jeremy Charles DeWitte. Comes now the affiant Detective Michael Warner, State of Florida Department of Financial Services, Division of Investigative and Forensic Services, Bureau of Insurance Fraud, a sworn law enforcement officer, makes this affidavit, which has been personally submitted to the court. This affiant swears under oath that he has probable cause to believe and does believe that certain laws have been violated in Orange County, Florida, and that beginning on March 22, 2020, Jeremy Charles DeWitte, herein referred to as the defendant, did violate several Florida state statutes and commit the felony offenses of Count 1. False and fraudulent motor vehicle insurance application felony level 3. Count 2. Failure of sexual offender to report insured vehicle felony level 3. Count 3. False and fraudulent motor vehicle insurance application felony level 3. Count 4. False and fraudulent insurance claim under $20,000 felony level 3. Count 5. Communications fraud over $300 felony level 3. Count 6. Staged motor vehicle crash felony level 3. Count 7. False and fraudulent insurance claim under $20,000 felony level 3. Count 8. Communications fraud over $300 felony level 3. Count 9. Organized scheme to defraud under $20,000 felony level 3. This affidavit has been submitted for the limited purpose of developing probable cause for an arrest warrant. All facts discovered during the investigation have not been included. Nearly all recorded statements obtained by your affiant in the course of this investigation were surreptitiously recorded in accordance with FSS 934.032 C. On March 22, 2020, a motor vehicle insurance application was submitted to Esurance Insurance Company. Your affiant reviewed this application. The application was insurance coverage for a 2004 Dodge Durango and a 2008 Ford F-250, and the address on the policy was within Orlando, Orange County, Florida. The insureds on the policy were listed as Rania DeWitte, the defendant's wife, and an additional driver was added to reflect J. DeWitte, a known alias of the defendant. The insurance application had a statement printed on it which read, "You have indicated that none of the above vehicles are used to carry persons or property for compensation or a fee, or for retail or wholesale delivery, including but not limited to the pickup or delivery of goods such as magazines, newspapers, mail, or food. You also confirm that none of the above vehicles are owned or leased by a partnership or corporation, leased or rented to others, registered or titled to a business, corporation, partnership, or DBA, or driven by an employee. You have indicated that none of the above vehicles are equipped with equipment used to support a business or with special equipment such as snowplowing, cooking, catering, racing equipment, or bathrooms and do not have an altered suspension or hydraulic lift. Your affiant reviewed 2 recorded telephone calls between the defendant and Esurance Insurance Company. On March 22, 2020, the defendant called Esurance because his credit card changed and he needed to provide a new credit. The defendant identified himself as J, which is the alias the defendant used on this policy. The defendant learned his motor vehicle insurance policy canceled on March 10, 2020, so he decided to obtain a new one. The first call was disconnected, so the agent called the defendant back. The defendant answered the phone, Metro State, and when the agent asks for Jay, the defendant stated it was him speaking. The defendant verified his Gmail email address and accepted the terms of the policy online with the agent. The defendant even stated he was able to log into the online account for the new policy while on the phone with the agent. Based on the information provided, Esurance insured both vehicles under policy number XXXXXXXXXXX. A check of the VIN off the Dodge Durango through the Florida Driver and Vehicle Information Database, David, revealed it was registered to Mrs. DeWitte. A check of the VIN of the Ford F-250 revealed it was registered to Metro State Special Services Vehicle Protection Unit, which was a funeral escort business. A search of the Florida Division of Corporations revealed that business was, at the time, owned by Jeremy DeWitte, a known alias of the defendant. Eurofient obtained a statement from an employee of Esurance which stated had the truth been revealed about the sirens, lights, and decals on the vehicles, the insurance policy would not have been issued. On December 14, 2020, Eurofient met with Mrs. DeWitte to interview her regarding this insurance application since she was listed as the named insured, despite the recorded calls of the defendant applying for the policy. At the time, it was believed Mrs. DeWitte was an additional suspect in this case. Mrs. DeWitte informed Eurofient in a sworn, audio-recorded statement, "My husband, the defendant, takes care of this, the insurance, and he, the defendant, is the one that got me the policy, and I don't know what's going on. He's the defendant taking care of my insurance, and my husband, the defendant, put my name on the policies." Eurofient directly asked Mrs. DeWitte who applied for the Esurance insurance policy, and she stated, "I didn't apply for any of that, like he put my name in there." When Eurofient asked who it was that used her name, Mrs. DeWitte answered, "My husband." As a detective of the Bureau of Insurance Fraud, Eurofient knows it is a common scheme for a defendant to provide a false and misleading application on a motor vehicle insurance application when vehicles used for business are being insured. As commercial motor vehicle insurance is more costly due to the greater risk to the insurer, oftentimes defendants commit motor vehicle insurance application fraud because they either cannot afford the premiums or hope the false and misleading information submitted on the application will never come to light so they can get away with paying a lower monthly premium. Count 2. Sexual offender failed to report insured vehicle felony level 3. To support this investigation to prove the defendant submitted insurance applications and documents in support of insurance claims, Eurofient requested the defendant's sexual offender registrations for several years from the Orange County Sheriff's Office, including all of 2020, which Eurofient knew would have the defendant's email addresses, telephone numbers, and other personally identifiable information. The defendant was convicted in Orange County, Florida of lewd or lascivious battery, 2005 CF 000394A0, and as such, is required to register as a sexual offender in accordance with S.943.0435. On February 28, 2020, the defendant completed a sexual offender registration with the Orange County Sheriff's Office. On this date, there were 21 vehicles listed on the defendant's sexual offender registration, which the defendant signed. Also included on this registration signed by the defendant was the following statement. As a sexual predator or sexual offender, I understand that I am required by law to abide by the following. Vehicles owned means any motor vehicle as defined in which is registered, co-registered, leased, titled, or rented by me, a rented vehicle that I am authorized to drive, or a vehicle for which I am insured as a driver. The term also includes any motor vehicle as defined insured which is registered, co-registered, leased, titled, or rented by a person or persons residing at my permanent residence for 5 or more consecutive days. I must report any changes in vehicles owned within 48 hours in person at the sheriff's office. Failure to report this information within 48 hours is a third-degree felony. It should be noted, the sexual offender registration form signed by the defendant had the above sentence in bold, capital letters, just as it is printed here. The sexual offender form signed by the defendant had this statement just above his signature, with the same bold, capital letters as printed in this affidavit. As a sexual predator, Florida Statute 775.21, or sexual offender, Florida Statute 943.0435, 944.607, or 985.4815, I am required by law to abide by the requirements listed on this form. By signing below, I acknowledge that I have read or have been read the requirements on this form, and that I understand these requirements. Under penalty of perjury, I declare the above is true and correct. On March 22, 2020, the Esurance Insurance Company motor vehicle insurance policy from Count 1 in this affidavit became effective. This motor vehicle insurance policy listed the defendant and his wife as rated operators, insured drivers. This motor vehicle insurance policy insured a 2008 Ford F-250 despite this vehicle being registered to the defendant's business, Metro State Special Services, Vehicle Protection Unit since 2018. It was not listed as one of the 21 vehicles on the February 28, 2020 sexual offender registration. On April 13, 2020, the defendant updated his sexual offender registration at the Orange County Sheriff's Office. Despite the same definitions, warnings, and the defendant's signature on the registration stating he understood the requirements and registered all vehicles, the defendant once again did not register the 2008 Ford F-250 which he was insured to drive. On May 12, 2020, the defendant updated his sexual offender registration at the Orange County Sheriff's Office. This time, the defendant added the 2008 Ford F-250 the time period between the defendant becoming an insured driver of this vehicle and when the defendant registered this vehicle on his sexual offender registration was 51 days, well past the 2 days required by law, and to which the defendant signed a statement accepting that he understood he only had 2 days to report this information. On March 29, 2020, a motor vehicle insurance application was submitted to Permanent General Insurance Corporation, also known as the General. Eurofiant reviewed this application. This application was for insurance coverage for a 2012 Dodge Charger and a 2011 Dodge Charger and a 2010 Dodge Charger and a 2009 Chevrolet Impala police package, and the address on the policy was within Orlando, Orange County, Florida. The named insured and applicant was listed as the defendant's wife. The applicant was listed as a single female who had no other household members. All vehicles were listed as personal use, and all vehicles were listed as having no prior damage. Despite being listed as having no prior damage, the defendant filed an insurance claim for collision damage on the 2012 Dodge Charger 2 years earlier in 2018 through Geico Insurance Company claim. There was also an additional questionnaire included with the application. One question asked, are any listed vehicles used to conduct business or to perform work or occupational requirements? Unacceptable business use for any listed vehicle includes but is not limited to operation by or transportation of clients or employees, delivery of products or services, titled in a company name or provided by an employer, display of a company logo. The defendant answered no to this question. Listed on the application was a statement which read, any person who knowingly and with intent to injure, defraud, or deceive any insurer files a statement of claim or an application containing any false, incomplete, or misleading information is guilty of a felony of the third degree. At the time of this application, the 2010 Dodge Charger was registered to Metro State Special Services, and the remaining 3 vehicles were registered to Metro State Special Services Vehicle Protection Unit. At the time of this application, Metro State Special Services Vehicle Protection Unit was registered to Jeremy DeWitte, a known alias of the defendant. On December 14, 2020, your affiant met with Mrs. DeWitte to interview her regarding this insurance application as well as another insurance application she was listed on from Esurance Insurance Company. Mrs. DeWitte informed your affiant the defendant obtained the insurance related to the Esurance insurance application. She stated, in part, "I don't know what's going on. He's the defendant taking care of my insurance, and my husband, the defendant, put my name on the policies." When questioned specifically about the general, Mrs. DeWitte informed your affiant in a sworn audio-recorded statement, "I did not put myself on any of this insurance." When your affiant showed Mrs. DeWitte which vehicles the insurance policy from the general covered, she stated none were hers. Your affiant obtained an affidavit from a representative of the general which stated, in part, "The general does not issue insurance policies for commercial motor vehicles, and had the truth been provided on the application, the policy would have never been issued." As a detective of the Bureau of Insurance Fraud, your affiant knows it is a common scheme for a defendant to provide false and misleading application on a motor vehicle insurance application when vehicles used for business are being insured. As commercial motor vehicle insurance is more costly due to the greater risk to the insurer, oftentimes defendants commit motor vehicle insurance application fraud because they either cannot afford the premiums or hope the false and misleading information submitted on the application will never come to light so they can get away with paying a lower monthly premium. Count 4. False and fraudulent insurance claim under $20,000. Count 5. Communications fraud over $300 felony level 3. On May 15, 2020, a motor vehicle crash occurred in Orlando, Orange County, Florida. The crash report indicated the crash involved a 2009 Chevrolet Impala registered to Metro State Special Services Vehicle Protection Unit and a 2015 Nissan Rogue. The crash report indicated the Nissan Rogue was insured by Garrison Property and Casualty Insurance Company, a subsidiary of USAA Insurance Company. Your affiant obtained the claim file from USAA Insurance Company for his insurance claim. On May 18, 2020, the claim notes indicated J. DeWitte, a known alias of the defendant, called USAA Insurance Company to initiate an insurance claim. USAA Insurance Company provided a recorded telephone call on this same date in which the defendant identified himself by name and described his account of the crash. On June 4, 2020, the defendant made another recorded statement to USAA Insurance Company. The defendant stated the other driver did something like a pit maneuver on his Metro State Special Services Vehicle Protection Unit vehicle, but he was able to recover from it and slowed to a stop. The defendant stated he provided his own dash camera footage to the trooper, and once the trooper saw it, he stated, "Oop. Yeah. There it is," and determined the other driver changed lanes into the defendant's vehicle and determined she was at fault. The defendant stated he was able to drive his vehicle away from the crash scene, and no one required any medical attention at the scene. Despite all of his statements, the crash report does not list the defendant as a driver or passenger involved in this crash, and instead listed one of his employees as a driver. Also included in the claim file were several emails from the defendant's email address to USAA Insurance Company. Once your affiant requested this claim file, USAA Insurance Company looked into the metadata from several photographs the defendant submitted in support of this insurance claim. On June 7, 2020, The defendant utilized his email and submitted 6 photographs of alleged vehicle damage from this crash in support of the claim. The email stated, in part, attached are the images of that night. Not the best. USAA Insurance Company utilized a program to review metadata from photographs. 3 of the photographs showed no metadata. 1 was taken around the time of the crash. However, 2 other photographs were taken on July 3, 2017, nearly 3 years prior to the crash. Later, still on June 7, 2020, the defendant again utilized his email and submitted 7 photographs of alleged vehicle damage from this crash in support of the claim. The email stated in part, broken or shorted equipment. 1 photograph showed no metadata, however 5 were taken in 2019 on January 6, 2019, 2 on September 23, 2019, and 2 on November 4, 2019, and 1 was taken on July 3, 2017, all prior to this crash. On June 16, 2020, the defendant again utilized a Gmail and submitted an invoice from Audio Excellence Incorporated in the amount of $1,852.04 for a 4-man labor team, which the defendant stated was to work to replace and set lights back up. Your affiant immediately recognized this invoice from another fraudulent insurance claim filed by the defendant in Polk County, in which criminal charges are pending with the Polk County State Attorney's Office under DIFS case number 22-3764. The defendant utilized this same invoice to fraudulently obtain money from Amica Mutual Insurance Company and an insurance claim Metro State Special Services was involved in from Polk County in 2018, years prior to this crash occurring. The invoice number was the same on both invoices from both claims. Your affiant noticed, however, the date was printed on the invoice, February 25, 2018, in the 2018 claim from Polk County, but was removed from the invoice when submitted in support of this claim, so it would not be determined this invoice was printed years prior to this crash and insurance claim. In support of the Polk County case, your affiant met with the author of the invoice, who was a store manager at HG2 Emergency Lighting, formerly known as Audio Excellence Incorporated. He informed your affiant this invoice was only an estimate, and no money was ever received from the defendant, and this service was never provided, despite the defendant claiming reimbursement in the amount of $1,852.04, which he claimed he paid to Audio Excellence Incorporated based on your affiant's training and experience as a detective within the Bureau of Insurance Fraud. Your affiant knows it is a common scheme for defendants to reuse fraudulent invoices in multiple insurance claims across multiple insurance carriers to attempt to inflate the cost of money they are attempting to receive. Despite the majority of these photographs being taken several months prior to the crash, all of these photographs were submitted by the defendant via gmail.com to show alleged crash damage from a crash which occurred on May 15, 2020. The signature line of each email displayed, J. DeWitte, owner of Metro State Special Services. USAA Insurance Company was unaware at the time of payment these photographs were taken prior to the date of loss, so in addition to the $2,000 for injuries despite not being involved in the crash, the defendant was also issued a check from USAA Insurance Company for $7,490. The memo line read, Payment under Property Damage Liability Cover *J. DeWitte, 2009. Chevrolet Impala 4D Police Car. Count 6. Staged Motor Vehicle Crash Felony Level 2. Count 7. False and Fraudulent Insurance Claim under $20,000 Felony Level 3. Count 8. Communications Fraud over $300 Felony Level 3. On October 11, 2020, the defendant was involved in another motor vehicle crash in Orlando, Orange County, Florida. The defendant was driving a 2012 Chevrolet Tahoe, registered to Metro State Special Services Vehicle Protection Unit, when it collided with a 2008 Mercedes-Benz SUV, driven by Shamar Smith. Later on October 11, 2020, the defendant initiated an insurance claim with Mr. Smith's insurance carrier, Infinity Insurance Company, in which he claimed damage to the Metro State Special Services Vehicle Protection Unit vehicle, as well as neck and back pain. Your affiant later met with Jennifer Burton, who was a passenger in the defendant's vehicle at the time of crash, and obtained a sworn, audio-recorded statement. Ms. Burton informed your affiant the crash was not done accidentally, but it was done intentionally. She stated the defendant informed her he purposely collided with the other vehicle as it was attempting to go around the defendant's vehicle in a turning lane to cause this crash so he would be able to receive funds from an insurance claim and to protect the families in the funeral procession the defendant was in traffic with. Your affiant is unaware why the defendant would believe intentionally ramming into moving vehicles in an active roadway would protect anyone. But as a detective within the Bureau of Insurance Fraud, your affiant is well aware of staged crashes and the large settlements participants hope to earn from their participation in a staged crash. Ms. Burton's statement to your affiant that the defendant purposely collided with another vehicle so insurance money could be earned is in line with the intention of drivers of other staged crash cases your affiant has investigated and made arrests on. Your affiant interviewed the other driver, Shamar Smith, via Zoom at the request of his attorney. During the interview, Mr. Smith informed your affiant it was his belief the defendant purposely crashed into his vehicle as the defendant sped up for no reason and then the crash occurred. Due to issues with the recording, your affiant later met with Mr. Smith in person and obtained a sworn, audio-recorded statement in which he reiterated he believed the defendant purposely collided with his vehicle. He stated when he was changing lanes, there was plenty of room, and as he did so, the defendant accelerated into the rear of his vehicle on purpose. Mr. Smith also stated Mr. DeWitte later received a $10,000 settlement from Mr. Smith's insurance company, and due to the lies and false statements made by the defendant related to this crash, Mr. Smith now pays a higher monthly premium for insurance coverage. Your affiant reviewed the claim file related to this insurance claim from Mr. Smith's insurer, Infinity Insurance Company. On December 4, 2020, a subrogation manager from Infinity Insurance Company contacted the defendant via email and requested documentation of the damages claimed to the defendant's vehicle from the crash. On December 7, 2020, the defendant wrote an email from his gmail.com to Infinity Insurance Company in which he stated, "Good morning, we are attaching the images and invoices to this and the following emails, as needed to provide all documentation for the accident. Thank you and please contact us to finalize this ongoing issue." The signature line of each email displayed, J. DeWitte, owner of Metro State Special Services. On December 7, 2020, the defendant wrote an email from gmail.com to Infinity Insurance Company in which he stated, "Altogether the unit requirements to be put back in road-sick, with replaced equipment and lights as well as bumper and new stickers was over the 10K limit you advised he had. However, we will work with that and move forward as to the fact the truck has been off the road and costing us money on downtime, and everything else." In support of this insurance claim, the defendant sent several other emails between December 7, 2020 and December 15, 2020. All of the emails were from gmail.com, which was the email addresses the defendant listed as his own on his sexual offender registrations. Several of those emails included invoices and photographs for alleged costs incurred by the defendant to repair his vehicle from the crash. All of the emails had the same signature line, which was J. DeWitte, owner of Metro State Special Services. Your affiant observed 4 invoices sent from the defendant to Infinity Insurance Company in Support of this claim were also sent by the defendant to USA Insurance Company in support of another insurance claim, counts 4 and 5 of this affidavit, from a crash in May of 2020, 5 months prior to this crash. The defendant submitted the same audio excellence invoice for $1,852.04, which the defendant submitted in the USA Insurance Company claim, and from an insurance claim the defendant was involved in within Polk County, in which criminal charges are pending with the Polk County State Attorney's Office, IFS case number 22-3764. This use was the third time the defendant submitted this particular invoice to inflate the costs the defendant claimed he was entitled to after a crash. Just like in the claim from USA Insurance Company, the date of this invoice was removed. Eurofient also observed 2 sirens.com invoices submitted by the for $563.50 and $215.24, which were submitted in support of this claim and the defendant's USA Insurance Company claim, despite the crashes occurring 5 months apart and involving different Metro State Special Services Vehicle Protection Unit vehicles. Eurofient also observed an invoice submitted by the defendant from HG2 Emergency Lighting, formerly known as Audio Excellence Incorporated, for $455.80, which was submitted in support of this claim and the defendant's USA Insurance Company claim, despite the crashes occurring 5 months apart and involving different Metro State Special Services Vehicle Protection Unit vehicles. Eurofient also observed an invoice submitted by the defendant from Wired for Less for $852, which was submitted in support of this claim and the defendant's USA Insurance Company claim, despite the crashes occurring 5 months apart and involving different Metro State Special Services Vehicle Protection Unit vehicles. Eurofient also observed an invoice submitted by the defendant in support of this insurance claim from Audio Excellence for $13,716.27, which included several items specifically for motorcycles. Although the defendant did have several motorcycles in use for his business, this crash involved a Metro State Special Services Vehicle Protection Unit Chevrolet Tahoe, so there was no legitimate reason the defendant should have been claiming motorcycle parts for replacement. Eurofient also observed 4 photographs submitted by the defendant in support of this insurance claim, which alleged to show damage to the Metro State Special Services Vehicle Protection Unit Chevrolet Tahoe involved in this crash. These 4 photographs, however, were also submitted by the defendant in support of the USA Insurance Company insurance claim. USA Insurance Company checked the metadata on the photographs and discovered they were all taken in 2019, the year prior to this crash. Based on Eurofient's training and experience as a detective within the Bureau of Insurance Fraud, Eurofient knows it is a common scheme for defendants to reuse fraudulent invoices and/or reuse photographs in multiple insurance claims across multiple insurance carriers to attempt to inflate the cost of money they are attempting to receive. On December 15, 2020, the defendant wrote an email at gmail.com to Infinity Insurance Company in which he stated, "Good morning, attached is the release you needed signed. Please email us or call once check is cut and mailed, so we are able to keep an eye for its arrival. Metro State Special Services. Thank you for your timely actions in this matter. That Tahoe was just added to our fleet. It was for years the owner's personal truck. Now it's one of the road units. Anyhow, again, thank you for quick actions in this matter." Eurofient observed the attached release in which the defendant's business, Metro State Special Services Vehicle Protection Unit, agreed to accept $10,000 from Infinity Insurance Company in exchange for the business and the defendant releasing Mr. Smith from any and all damage claims. On December 15, 2020, Eurofient observed the claim file notes from Infinity Insurance Company indicated they received the release and were issuing payment to the defendant for $10,000. Count 9 organized scheme to defraud under $20,000 felony level 3. From March 22, 2020, to December 15, 2020, the defendant engaged in a systematic, ongoing course of conduct with intent to defraud several auto insurance companies by false or fraudulent pretenses and representations. The defendant submitted false and fraudulent motor vehicle insurance applications to pay a lower insurance premium. The defendant submitted the same photographs and invoices to insurance carriers in each insurance claim, claiming the invoices and photographs related to that specific claim, and the defendant intentionally caused a crash in order to obtain insurance proceeds. The defendant received insurance settlements from these claims which he would not have otherwise been entitled to had he been truthful as to the facts of loss and damage sustained. Wherefore, your affiant prays that a warrant be issued commanding the Director of the State of Florida Department of Financial Services, Division of Investigative and Forensic Services, or any of his duly authorized law enforcement detectives, and all sheriffs or any of their duly authorized division deputies to arrest Jeremy Charles DeWitte and bring him before the court so that he may be dealt with according to law. Obviously, there was an arrest warrant issued for these crimes, and Jeremy was arrested while already being held on similar felony charges from another case out of another county. Jeremy has such a large history of felony charges against him that each of these 9 felony counts that he is going on trial for starting on June 16, 2025, have enhanced sentencing guidelines due to his habitual offender status. As I have stated in other videos, Jeremy has 75 different cases, not charges, but cases in Orange County alone dating back to June 26, 1998. Many of these cases are containing multiple crimes. Most know of Jeremy's continued desire to pretend like he is a law enforcement officer when he is not and never has been one. He also pretends to have been in the military, which is also untrue. His never-ending desire to be someone of importance has only led him to be right where he should be, and that is in prison, facing many years and in so much debt that he will probably never be able to repay. It is actually a very sad story because, as you have heard in this video, he made decent money with his company that he didn't need to do any of this. His desire to be somebody important only led to him showing the world what a low-class person he really is. He also brought down so many others with him, but it's hard to feel sorry for any of them since they saw firsthand and choose to stay anyway. I hope the people of Orlando sleep better now knowing this person is not on the streets for many years to come. And to all the victims of his crimes, I hope you have some satisfaction in knowing he finally got what has been coming to him for a really long time now. Thanks for watching, everyone.